save the United States, the state of Tennessee, and this honorable court. Be seated.
Good morning. Always glad to see everybody here. It's nice. We're still enjoying being back in person in oral arguments. Call the first case, please.
Gabriel Calleja versus Whitney Bradfield.
We'll hear from the appellant when you're ready.
Cecilia Peterson, the appellant, Calleja.
Okay, I'm sorry, wait, could you get in front of the microphone first and pull it down?
Cecilia Peterson, counsel for appellant Gabe Calleja. I got his name wrong the first time, too. I'd like to reserve 5 minutes.
That'll be fine.
With all due respect to the court below, the court committed 2 definitive errors. There were other errors, but these were definitive, determinative to this appeal. The first is that the trial court committed an abuse of discretion by applying the wrong statute in its analysis. The second is that the court's ruling was not based upon the best interests of the minor child, but rather upon the relationship between the parents and the court's displeasure with the father's conduct, which did not in any way affect the best interests of the child. There are 2 different statutes that could be applied in a post-parenting plan situation. TCA 366106 governing custody and 366108 governing relocation. This is a relocation case, and the court, nor the parties, nor counsel, nor, from my personal experience, mediators, get around the relocation statute by agreement or a parenting plan language or anything like that. It has been tried before. This court has faced it before. Back in the day, when the relocation statute was broken into 2 parts, then the trial court was to analyze it one way if it was substantially equal co-parenting time, and another if it was not. And it became very difficult for parties or mediators or counsel to get them to agree to a parenting schedule other than substantially equal co-parenting time, even when everybody knew that was not what was in the best interest of the minor child. So we got creative, and we would put provisions in Section J of the parenting plan that said stuff like, if either party moves out of the school district, it's a material change of circumstances warranting a transfer of custody to the non-relocating parent. Or if anybody moves more, and this is back when it was 100 miles, more than 100 miles, we're going to treat it as if it's an equal co-parenting time situation. And back in the day, the statute also provided that if it was substantially equal, you did go to 366106. That all changed in 2018. At that time, the statute was amended to say, we have specific factors to apply to relocation to ascertain if the relocation is in the best interests of the child. So it's not as much of a comparative fitness analysis as it is under 106, but rather, does the child have special needs?
Well, counsel, the court was concerned about the very issue that you raised here, and during the case, the court asked counsel for both sides. I'm under 106 here, 108. Only one side chimed up at that point.
I think both parties, both counsel ultimately said, yes, it's a 106 case, but they were in error.
So what do you do? I mean, it seems like in that event, then, the error was something that could have been corrected earlier, and both parties seem to ride under 106. I mean, surely you don't send it back in that sort of circumstance, since both sides really invited this error.
That's what I'm saying to the court, is that in Ray Blake, the Middlesection Court of Appeals actually ruled that it was error for the trial court to rely on the language in a parenting plan that tried to get around the relocation statute. The relocation statute is designed specifically to see what is going to be the impact on the child, Does the child have special needs? How are we going to do visitation? What's going to happen to the relationship with the non-relocating parent? Those are factors specific to relocation.
Well, we've had at least 2 cases that I'm aware of. Dayoff against Caffey and In re Lucas SM, where we've looked at the converse situation, where the court applied 108 and we said 106 should have applied. But in both those cases, we determined that because at the heart of both statutes was the child's best interest, it really was not an error that justified reversal in that case. So why should we depart from that precedent?
That is not actually, well, the law says you should apply the statute that applies. And if there are 2 statutes, the legislature intended for both of them to be in concert. If 106 was good enough, why would they have enacted 108? Why would we have a relocation statute for relocations? We're supposed to apply the law that applies. While it would have been great if everybody had done the right thing, they didn't, and it needs to be analyzed under the appropriate statute. And in any event, as I said earlier, it does not appear that the court made his determination based upon the best interests of the child. He punished the father, and he made it clear in his announcement as to the plan that he was ordering that it was in the nature of punishment, that it's a close case, a really close case. But I'm going to tell you, I'm going to leave the child with the mother.
Counsel, what do you say, as I understand the part of the opposing counsel's argument is that, look, 106, 108, the relevant factors of 108 were really covered in 106. There's really not that much of a difference between them in this case as to the relevant factors.
Well, let's look at that, Your Honor. Under 36-108 2B, the trial court must consider how the move will affect the child given any special needs of the child. This case hinges on the special needs of the child. There was 0 testimony about the availability of services in Enterprise, Alabama, speech therapy, feeding therapy, behavioral therapy. This child has some substantial behavioral issues that affect his ability to be in a classroom setting. He's in need of feeding therapy and speech therapy, things that the mother rejected and then said, but I have no problem with the care the father got. And then even in her brief today on page 37, she says, this child doesn't have any feeding issues in my home. Now, you can't have it both ways. You either recognize it and deal with it as the father did, or you don't recognize it, refuse to recognize it, refuse to deal with it as the mother did, and the child is left in want of these very critical therapies. Instead, though, of focusing on things like, are there services available in Enterprise, Alabama? The court said, I'm going to do this because Dad didn't inform the mom that the child was receiving medical treatment, and not just any medical treatment, but psychological treatment.
Isn't the ability of the parents to work together, though, part of the best interest consideration, though?
Sure it is, Your Honor. She won't work with him. He testified, and she really didn't rebut. She says, I don't recall that he would raise an issue. This child has a feeding problem. And she'd say, no, he doesn't. And then the school and the father raised the speech therapy issue, and she refused to acknowledge the need for it as well. So the father proceeded and got it basically in secret. And that's good behavior. I cannot say so. It would be great if she said at that time, well, let's look at it and work together to see what can be done. But she didn't. She just refused, flat out refused. And when she found out about it, she shut it down. Now, she calls it, I just put it on hold, but but basically it was exactly what he feared would happen. Even though she later acknowledged it was good, we have, and the court ordered that they get a further evaluation. In the mother's brief, she claims that there was testimony they were already working together to get the evaluation. Well, I've looked at that transcript over and over and over again. I summarized it line and page, and that testimony is not in there. In short, even if the therapy is available, the mother has indicated she won't get it. It should have been analyzed under whether it's available and whether she would get it, and the court shouldn't have done what he did to punish the father.
Thank you, counsel. You have your time for rebuttal.
Thank you.
We'll hear from the appellee.
Good morning, Your Honor. I'm Bill Minott. I represent the mother in this case, Whitney Bradfield. I don't think it's any great surprise that we don't agree on the facts in this matter, and we don't agree exactly on how the facts were part of the transcript. I am fortunate that I don't get to give you one of your least favorite answers if you ask me questions today, which is I was not the trial counsel. I was the trial counsel. There was discussion about whether or not 106 or 108 were the appropriate statute to apply. And I think the very reason that the question came up brings to light a problem that is going to have to be addressed one way or the other, and that is this. As we're moving towards fulfilling the requirements of the first clause of Section 36-106, which talks 36-6106, which talks about the requirement that you maximize the parents' presence in the children's lives. Some judges mean that starts from a 50-50 and works backwards. Some judges think I have the same discretion I had before, but it is resulting in a lot more mixes of parenting time than we just used to think of as the standard co-parenting time. This is a unique case, but it's becoming less and less unique. These parties were never married. They had a child. They moved to Tennessee about the time, just right before they had the child in 2017. Very soon after the child's birth, the parties separated and were informally splitting time prior to the entry of a permanent parenting plan. I think father was afraid that mother, with no connections to the state of Tennessee, would try to relocate with the child to Florida, so he filed a parentage action, and we went through that and eventually put down a permanent parenting plan that formally split time between these two parents in a 50-50 week off split. Well, mother had some incidents come up in her life. She was working for a law firm. She enlisted in the Army. She had the opportunity to take a trip with the Army and did. And on that trip, about 2.5, 3 weeks long in Europe, it was not a deployment, but it was away from the family. She met a gentleman, and over the rest of that summer after she got back, they communicated further. And he was stationed at Fort Bragg, North Carolina. I get them backwards. Fort Bragg is in North Carolina. And he had received orders that he was going to be transferred to Fort Rucker, Alabama. Mother at that point decided that she was going to go with him, and in December of that year, 2019, notified father under the relocation statute that was her intent. Well, her lease ran out on her apartment, and she went ahead and went to Fort Bragg in North Carolina, where her current husband was at the time. And then COVID intervened and the orders got changed, and they ended up staying in North Carolina significantly longer than they intended. What's unique about that is that these parties continued with a 50-50 split of time, and mother was doing all of the transportation at that point back and forth from where she was and where the child was, and they were exchanging once a week. There was testimony about how they set up a way that the parties could each talk to the child by video conversation every single day. Now, the parenting plan requires twice a week, but mother went out of her way to make sure it was every single day. When the orders came through to go to Alabama, they moved to Alabama, and mother asked the father to do a mediation, and they came up with a similar 50-50 split, but they decided to do the transportation every 2 weeks. this went on a long time. There were several trial dates that simply COVID-19 and other health factors caused him to be put off, and eventually, well, the trial didn't even come to until May of 2022. By this time, the petitions had been pending for several years, and the child had been going back and forth for several years. Now, so the court is faced with, here is a case where there has never been a comparative fitness done between these two parents at all. And I tend to the court that that's likely to come.
Counsel, excuse me for interrupting. Relative to the statutory schemes, did the parties invite error in this case?
I don't quite understand the question.
Did the parties suggest that 106 was the applicable statute?
To be honest, Your Honor, I believe the judge suggested 106 was the applicable statute, and we did have some short conversation about it, but determined that if 106 was not appropriate, that 108 was included in the factors of 106. I don't know how the judge made his decision about that specific thing. There was discussion about it. If you're asking if either party misrepresented to the court, I don't believe that's the case.
Well, did either party say it's not 106, it's 108? This is a relocation case. I mean, you agree it's a relocation case?
I do, but I don't. I think the real answer to the question is that when the court looked at the factors of 106, it looked at a much broader spectrum of factors regarding the custody between these two parents, where no court had ever done that before.
Well, I mean, we're faced with the fact that the General Assembly has made the policy determination that we're going to have two separate situations here. One of them involves a relocation. And here's what we're going to set out as a matter of policy for the courts to consider in the relocation. So,
well, I think it's worthwhile
explain to me why it's not an error.
I think it's worthwhile to look at the...
Let me finish, Mr. Meyer.
I'm sorry.
That's okay. Why it was not an error for the trial court to apply 106 in this clearly relocation, and then still try to maximize the amount of time that the child gets to spend with both people, with both parents, depending upon what the determination is as to the relocation.
Well, I think it's worthwhile to look at the two statutes, because they're, if you actually look at the language of the two statutes, they're very, very similar. And frankly, I could only find two things that are in 108 that are not in 106. 106.1, A1, I think, covers a significant portion of the rest of them when in 108, when it talks about the child's relationship with the parent, who was the primary caregiver, who was giving care for the child. Well, that's actually the same as, almost word for word, as 2A, which is the nature, involvement, and duration of the relationship with the parent and the child and the relocating parent. I think that's included in that.
Well, what were the two you said you found that were not?
Well, interestingly enough, one of them is continuity, which was a big portion of the appellant's brief. Now, I know that there's case law that addresses continuity in a relocation situation, but continuity in and of itself is a specific requirement in the determination of 106, and it is not in 108. The other is basically a question which I think is also general enough to be addressed in all of the factors of 106, which is subsection F of 108.2, which is whether or not the relocation will enhance the general quality of life of the child. And so the court had the opportunity to hear evidence about the home life and the educational life and the medical life of the two parties throughout the entire hearing, and did make a determination. And basically, he used the factors of 106 in order to determine whether the factor of 108F could be used to fall in favor of the father or the mother. Counsel talks about, in her argument, talked about the court being mostly affected by the father's misconduct, and that the court was punishing the father for what he did. But I think it bears a little bit of examination to figure out exactly what the court was reacting to. These parties had been doing a 2-week on, 2-week off split, and in late December, of 2021, mother received an EOB from her insurance company that had a medical care provider that she didn't recognize. When she called and investigated that medical care provider, she found out that the father had been taking this child to this therapist, this therapy organization, for a substantial period of time without telling her. She did not call a halt. She asked to have a meeting. She testified she asked to have a meeting with those counselors, and once she did raise a few issues that she thought were important to address as well, and then continued the care of the child under those counselors. But I think the court was also looking at some other thing about that. The counseling escalated and escalated and escalated, and the counseling was eventually 5 days per week when the child was with the father. And I questioned the father about, well, tell me what you all do during the day. And his entire list of things that the child did during the day was fulfilling the tasks that were being set forth with the child in therapy, or what the father had been directed to do in order to deal with the child. This child wasn't just having therapy, and it wasn't just that the judge was upset with the father for not telling mother about it, although that's bad enough and a violation of the parenting plan. This judge was shocked by the amount of time and therapy session that this child was in at prior to being 5 years old. This isn't a teenager who has some ingrained problems that need to be dealt with. Now, counsel also talks about whether or not this child, and in fact, in her brief, used the term eating disorder. Well, there's nothing in any of the evidence presented to the court that suggests this child has an eating disorder. The testimony before the court in that case was...
Well, other than the father's testimony, the child was losing weight.
Sure, I agree, and I think that, and that's where I was going. I think that an eating disorder is a term of art. I think what the father testified to, and what counsel has stated today, is that the father had trouble getting the child to eat the things the father wanted the child to eat. And therefore, the child has some sort of eating problem. The mother's response to that was, when I feed the child eats. Now, there was question about, is there ever time that the child won't eat? And she said, sure. I always cook the meal for the family. I try to get Kylan to eat what the family is eating. And here's the list of things that I know he'll eat that I'm prepared to make if he won't. I mean, this is not a situation that the father wants to portray where the mother is completely ignoring any kind of problems at all. There was testimony about the child's life in Alabama. There was testimony about the school that the mother intended to enroll the child at. There was dispute between the parties about that because she wanted the child to go ahead and start kindergarten. And the program that she testified that she was going to put the child into did have it had a K4 and a K5 program, and they were going to place Kylan in the K5 program and then move him to where they needed to be once they determined his situation. But there was testimony that the parties were going to comply with what the judge ordered about the special issues. Now, keeping in mind, even after all of the therapies that the father had put the child through, there was still no proof presented at court of medical evidence of any actual diagnosis of a problem of the child. The child had issues and they were dealing with them. But I think part of the problem was that the father didn't know how to handle the child, was seeking help in handling the child, and it got out of hand. I don't think the court was punishing him. I think the court was finding that what the father was doing was not in the child's best interest, which is what the court was trying to do in that case. The court above, the appellate court, has to give a significant amount of deference to the determination of the court below. And the court is not to put its judgment in when, according to the Eldridge case, when the court has done something below that fits within the parameters of what could have been the result if the proper test had been applied. So the court here was faced with
isn't that the key, though, the proper test? I mean, both sides here seem to acknowledge that 108 was the proper test.
Certainly, but my brief...
106 is the one that was applied.
Certainly, but my brief argues throughout that even applying the 108 to the facts found by the court as applied through the 106 interpretation, would have resulted in the same result. Because let's face it, the court had to make a decision between these two parents and where the child was going to live. The court didn't have any choice about that. The imminent arrival of the school year put it in a situation where the 50-50 split, which hadn't been the best arrangement, but had been working between the parties, was no longer going to work. So I asked,
That 50-50 split that had been established, that was pursuant to a court-ordered parenting plan?
yes, Your Honor. And they did expand it by agreement under order to 2 weeks instead of 1 week.
2 weeks on and off, yes.
But I think that the court should find that the error below in applying that statute was not reversible error and should give deference to what Judge Irwin did below. In the alternative, the court, I suppose, could remand the case back to Judge Irwin with an order to apply the factors set forth in 108. I'm confident he's going to come up with the same result. Thank you.
Thank you. Hear from the appellant, excuse me, we'll hear from the appellant in rebuttal.
Thank you, Your Honor. The Mother's Council clearly attempts to have it both ways. It should have been 106 and the court applied it appropriately. Well, that's not true. If it was 106, the custody statute, section 10 of that statute tells the court that the importance of continuity and stability is a factor that the case law has held is significant. So the court said, well, in a relocation case, we can't maintain continuity, so I'm tossing that one out. The testimony was, and this was from the mother and her fiancé, she had moved from Knoxville over to Fort Bragg, down to Fort Rucker. They were going to stay there for 3 years, and then in 3 years, he was not going to re-enlist, but was going to retire and move to places unknown, probably Texas, and she could tag along. You know, that's the stability in line for this child, is that we're going to take this relationship with the father where he had equal co-parenting time and reduce it somewhat, because the judge did maximize as much time as he could for the child to be living in Alabama. But then the child's going to move another 1,000 miles away, and that relationship is gone. It is impossible to maintain a close relationship with an individual who lives across the country. FaceTime ain't going to do it. You know, you want to put the child to bed, you want to help the child with his homework, you want to take the child to sporting events. You know, these things cannot happen just during the summer.
I mean, but aren't all those factors that are present in pretty much every relocation case?
Not where you know that it's in advance that it's going to be unstable. That's the only difference here.
Talking about the distance, particularly from the anticipated move to probably Texas. I mean, if a parent is moving out of state to 3 or 4 states over, isn't the reality is that in all those relocation cases, those things you're talking about are going to be pretty much present. One parent is not going to be able to be there and do those daily things.
Divorce itself means that you don't get 24/7 access.
Correct.
I mean, you're going to have probably, in this day and age, 50% of the time. And if you're in a different state, one person or the other is going to have less than 50% of the time. But why should that result in the elimination of the parent-child relationship with the non-relocating parent, which is the factor the court's supposed to consider? Preserving the relationship. And the testimony was, we're out of here in 3 years, some of which has already elapsed. So the time's running out for this father to have a real role in his child's life. The court, the facts as stated by the mother are a little bit embellished. The court was not shocked by what the father did on a day-to-day basis. Counsel was, because he was wondering when's playtime, and, you know, this gentleman, thinking that regimen is necessary for a child with these needs, said, we schedule that too, you know. But the court didn't say anything about how he spends his time. He did say that he thought it was alarming, the amount of therapy. But you've got to understand, he could do it every other day if the mother was also doing it. But she wasn't. And anyway, The testimony was, and 106.4 and 108.2b are pretty much the same, except there was no testimony about the needs of the special needs of the child and how they would be met in Alabama. So that's different. That's different because historically, father met those needs, got punished for it, for not telling mother, but got a pat on the back at the same time. You know, it was bad form not to tell the mother. But if he was afraid, she would stop it. And as far as he's concerned, she did stop it. She called it putting a pause on it. But basically, she approved of the therapies that he got when she refused to do it. So who's going to do it in the future for this child? Things only get more difficult. I've had kids go through 3rd grade, you know. Things only get more difficult from here, and this child has special needs that the mother wouldn't address. Thank you.
Court thanks counsel for both sides. We appreciate your arguments this morning and your briefs.